Hello, everyone, and welcome to another edition of Employment Law Q&A. My name is Alex Lucifero. I'm an employment lawyer and partner with Samfiru Tumarkin, LLP. We are the employment lawyers. If you're in Canada, and specifically in the provinces of Ontario, British Columbia, or Alberta, and you're dealing with a situation at work, maybe you've been let go from your job, maybe your employer is treating you badly, maybe you're dealing with an abusive or harassing manager or coworker, or maybe there are changes happening in your workplace. Maybe your employer is asking you to take a pay cut or change position. All of these kinds of situations trigger rights, trigger protections that you as an employee have in the workplace. That is exactly what we are here today to discuss, what these protections are for employees. What rights do employees have when they're dealing with difficult situations at work? More and more nowadays, and it's the case every single year and increasingly so, employees are being put under pressure. Employers are downsizing, restructuring, tightening their belts, and the individuals, the people that feel these pressures that employers are putting on them for the sake of the bottom line, it's the employees of all these companies. Whether you are working for a small business, a medium-sized business, a large international corporation, you have the same rights and protections as any other employee has, particularly when it comes to something like severance. Unfortunately, nowadays we are seeing companies downsizing, lots of employees losing their jobs. You absolutely have to know what your severance entitlements are in those kinds of situations. You don't want to be one of those employees that accepts a severance package, that signs off on a severance package for pennies on the dollar of what you are actually owed. And oftentimes, almost always, in fact, your severance entitlements are going to be way more, much more significant than what your employer is offering you. Don't sign off blindly on a severance package. Make sure that you are being treated fairly, that the employer is being reasonable. Make sure you receive your proper severance entitlements. And the way you do that is to make sure you speak with an employment lawyer. You can also use, of course, our severance pay calculator that we have on our website. And speaking of, let's share some contact information here, guys. And as a quick aside, maybe more than a quick aside, but as a reminder here, this is a live Q&A. I see a couple of questions already coming through on the live stream. Please, if you're tuning in right now, go ahead and post a question. It could be very brief. It could be a paragraph long. Keep it confidential. You don't have to tell me who your employer is. You don't have to provide any confidential information. Ask a question generically, and I promise I will get to it before the end of the live stream. This is your chance. This is your opportunity to speak directly with an employment lawyer and get some guidance, get some information as to what options you have, what rights you have as an employee in the workplace. But before that, our contact information, everyone. If you're dealing with a very serious situation, you need help, you need to contact us right away. Oftentimes, employment issues are time sensitive. The longer you wait, the more they fester, the more complicated they get, and potentially the more difficult they get for you. So the easiest way to contact us, other than telephone number, of course, is our email address. Go ahead and email us at help@employmentlawyer.ca. It was on the screen a second ago. The email address is help@employmentlawyer.ca. Very straightforward and simple email address. Go ahead and send us a brief email about the situation that you're dealing with, and one of our intake team will get back to you. I assure you of that. You can also visit our website, of course. And listen, obviously on the website, we've got our contact information. We've got our list of lawyers and the different offices that we have across Canada. If you want to reach out to anybody specifically, individually, our contact information is there. Keep in mind our website as well. It's employmentlawyer.ca. Our website as well has a ton of information and resources. It is really the starting point if you just want to get a sense of what common employment issues are in the workplace, whether it's severance or whether it's temporary layoffs or whether it's changes to your employment or discipline or demotions. We've got a ton of resources on all of those subjects and more on our website, employmentlawyer.ca. Very easy. Punch it into your phone. Have a quick read. We've got videos. We've got a bunch of articles and blog posts on every single subject that you can imagine under the sun in the world of employment law. And of course, and I like to kick it old school once in a while. If you want to give us a call at the office, absolutely no problem at all. You can contact us by giving us a call. It's toll free, and you will be connected with someone in our intake team that can triage the situation that you're dealing with and then put you in touch with an employment lawyer or even a paralegal if need be. So that's our contact information, guys. Please go ahead and reach out. Again, if you're dealing with an issue at work, don't just sit on it. Don't just do nothing about it. You need to act, and oftentimes you need to act very quickly. Otherwise, you might be jeopardizing your employment rights and protections in the circumstances. So you want to get on that right away, particularly, if this is something that's keeping you up at night, if this is something that you're really stressing over, that you're anxious about, there's a reason for that anxiety. There's a reason you're stressing about that situation at work. And oftentimes there are solutions to those problems that the law will provide. We solve these kinds of issues at work. Again, whether maybe you're dealing with a difficult coworker at work that's, berating you or maybe micromanaging you, or you're dealing with a difficult boss or a difficult HR person at work. It's not a situation that should be keeping you up at night. There are solutions, and oftentimes very easy solutions to these problems. But the only way you're going to solve those problems is if you arm yourself with the proper information and advice and the tools, so to speak, to solve those kinds of workplace issues. And if you're dealing with something that's more serious, for example, again, if you've been let go from your job, that's when you really need to speak with an employment lawyer, and oftentimes use the assistance of an employment lawyer to help you negotiate a better package. Speaking of severance, and this is on our website as well, but I wanted to plug this very quickly because it's a very easy tool to use, and it's a great one. If you're worried perhaps about being let go, or you've been let go from your job, visit pocketemploymentlawyer.ca. It's on the screen right now, pocketemploymentlawyer.ca. We've got a severance pay calculator there that is an accurate assessment of what your severance entitlements could be. You don't have to provide any confidential information, your name or or any other information for that matter. You really just input your age, your position, and your length of employment, and it will give you an assessment of what your full severance entitlements are. You can also answer, if you're dealing with other situations beyond severance, constructive dismissals as a general term, changes in the workplace, in other words. Go ahead and answer a couple of questions at pocketemploymentlawyer.ca, and it will give you some information and advice as to what to do in those kinds of circumstances. So please reach out to us any way you can. Use the Pocket Employment Lawyer. Contact us, email us if you're dealing with a difficult situation at work, you need help, and we are here to help. That's what we do all day, every day as employment lawyers. We help people resolve those kinds of workplace problems. Again, for those of you just tuning in, this is a live Q&A, a live employment law Q&A. My name is Alex Lucifero. I'm an employment lawyer. And if you're dealing with a situation at work, now is your chance to go ahead and post a question, get your questions answered. Typically, at the start of these, I will talk about an issue that we're dealing with, that I've either spoken to somebody and wanted to kind of share their experience and share a bit of a lesson in the world of employment law. I'm going to park that. I've got one ready to talk about, an interesting situation that I dealt with late last week, but I see a number of questions lined up, and so I want to get to the questions right away. I don't want anybody hanging on with their question unanswered. So let's get right into the questions. This is the meat and bones of why we do these live Q&As. It's to answer questions on the fly, live. And so again, if you're tuning in, do not be shy to post a question, even if it's a very simple one. Maybe you have a question about retirement or pension plans, or you're just curious what your severance entitlements would be, or you're just dealing with a situation at work. Really, don't be shy. Go ahead and post it. Keep it brief, and I will help you, I promise, in answering and resolving that question. So first in line today is Philip L., and this is on YouTube, I believe. Philip asks, suppose there is a dispute and the employer insists A, while the employee insists B. So there's a dispute here. It's been brought up for 6 months. Should the employee bring this up to clarify the situation? Philip, interesting question, general question. So I think what Philip is asking here is when there's a dispute between an employer and an employee, should you kind of let this sit? It sounds like this has been sitting for Philip for 6 months. Should you bring it up to clarify and ultimately resolve the situation, or let it be? Philip, I have to say, in a lot of these kinds of employee-employer disputes, the enemy here is uncertainty. You want certainty when it comes to your employment, to your terms of employment, whatever the issue might be. And so, if there's this kind of ongoing, up in the air dispute between you and your employer, absolutely the answer to your question is yes, you want to bring it up. You want it resolved, kind of one way or the other. You need to know what your position is here with respect to this issue and what the employer's position is with respect to this issue. And sometimes, if that is completely irreconcilable, if there is a dispute with your employer and there is simply no common ground that can be reached, and ultimately the parties have to part ways, right? And you've got to go your own way because your employer simply isn't playing ball in a particular issue. I will say, Philip, in a lot of those situations, the employee will be owed severance if they ultimately decide to leave the employer. These situations are called constructive dismissals. A constructive dismissal occurs when an employer, and again, this is the situation that we see very often, Phil. Oftentimes, the employer will try to make a change to your employment and say, hey, employee, as of right now, I'm moving you from day shifts to night shifts. Or as of right now, I'm demoting you from a manager to a supervisor. Or it could be a change to your pay as well. It can also be something like a temporary layoff. These are major changes to your employment that, of course, as an employee, you are not going to be happy with. And they trigger protections and rights that the employee has. The protection that you have as an employee in that situation is that you can effectively quit. You can resign your employment in protest of that change, but still receive severance. So you are effectively quitting your employment with severance in that kind of constructive dismissal situation. And as you explain, when there is a situation that is irreconcilable, and let's say your employer is trying to force you to do something that you don't feel is fair, that you don't want to do, you may have the option of resigning, of quitting your employment, but still receiving severance because your employer was trying to force you to do something that you weren't willing to do. Now, I will put a caveat on these constructive dismissal situations, Phil, before anyone out there just ups and quits their employment or resigns their employment. Before you may think that you're dealing with a constructive dismissal situation, and odds are you may be correct about that. But before you do anything, before you take any kind of position with your employer about quitting or constructive dismissal, do yourself a favor, speak with an employment lawyer. These situations are delicate. They need to be managed properly. You need advice before you take that position. You oftentimes need to tailor how you're speaking to your employer, what you should be saying, what you shouldn't be saying. And the only way you can do that is by receiving advice yourself and effectively brainstorming and coming up with a little bit of a strategy and some tactics as to how you're going to approach resigning and then pursuing severance. So these situations are very delicate, require tailored employment advice. But Phil, if you're dealing with a situation where you're at an impasse with your employer, don't just do nothing. Don't just wait. Give us a call. Let's have a chat confidentially, privately. Come up with a game plan, and then you could approach your employer and say, "Hey, we need to resolve this, and it's my way or the highway." That's the right way to do it. And again, if you're dealing with that kind of situation yourself, or maybe you've got a friend or a family member that's dealing with a difficult situation at work, tell them, email us at help@employmentlawyer.ca. Give us a call at the office, contact us whichever way you want to contact us. But the situation needs to be resolved. You cannot let an employment problem linger. All right, up next is Bape, I believe, on YouTube. Bape asks, "Hey, Alex, hope you're having a wonderful day. Thank you. Same to you as well. If you are on modified, I'm assuming, Babe, you mean modified duties here. Can a workplace tell you that they have extended past your temporary accommodation and give you a new role with less pay? That's an excellent question, Babe. And I guess the answer to that question is, when you say temporary accommodation, what are we really talking about here? And ultimately, it is your doctor, Babe, that is going to dictate the terms, or that should at least dictate the terms of accommodations in the workplace. So, uh, if you are dealing with an injury that is going to be considered temporary and that you will ultimately recover from and be able to go back to your regular job, the answer to your question, Babe, is no, your employer can't do that. They should be accommodating you up until the point that you no longer need that accommodation. And then when you're recovered and when you're ready to return to your full job, they should allow you to go back to that position. Your employer cannot punish you because you need medical accommodations in the workplace. They also can't punish you because you need to take a medical leave of absence, for example. When the accommodation is done or when the medical leave of absence is done, you as an employee have every right to go back to the position that you left before you needed those accommodations or had to take that medical leave of absence. No less pay, no different a position. Everything has to remain the same as it was before. That is the employer's obligation. Now, if your employer is now telling you, well, sorry, we can't accommodate you anymore, you need to go to another position that has less pay, right? And you think that you will recover from the injury eventually, that's a no-no. Babe, your employer cannot do that. That may be, as we were just discussing, that might be a constructive dismissal in and of itself. Or at the very least, you might be able to get your employer to back down from putting you in that other position at less pay and reinstate you to your position. I want to insert a caveat here, Babe, because if you were a unionized employee, the situation may be slightly different in that you have to speak to your union about all of this. The general rules of accommodation in the workplace are the same, but if you're a unionized employee, you cannot necessarily claim constructive dismissal. Your union is going to essentially have to fight for your position back. There is a big distinction in the world of employment law between unionized and non-unionized employment workplaces. As non-unionized employees, you have every right to go speak with an employment lawyer and force the employer to play ball and to respect your rights and protections as an employee through an employment lawyer and through the use of an employment lawyer, and kind of individually as that individual employee. But when you are a unionized employee, your union is your legal representative, and your union is the only legal representative that can fight for you in these kinds of situations. Unfortunately, what we see as employment lawyers, and listen, don't get me wrong, unions are great for things like job security, pay, benefits, all of that stuff. Unions are great for, and unions are under attack nowadays, and that's an issue. That's a problem, in my opinion. However, when it comes to fighting for individual employees, or for example, when it comes to things like severance, I hate to say it, but unions will oftentimes fall short on those particular items. If your union is not supportive of you as an individual employee, I hate to say it, but your options may be very, very limited, because as a unionized employee, you can't go to an employment lawyer and seek that help necessarily. But as a non-unionized employee, you absolutely can. It actually makes it a little easier to fight for yourself as a non-unionized employee, because you've got that ability to seek legal counsel, to seek legal advice individually rather than through the union. Those, union organizations could get bogged down sometimes, and it makes things difficult sometimes for employees. So, Babe, if you're a non-unionized employee and you're in a situation where your employer is forcing you into a position with less pay just because you need accommodations for an injury or a disability, that is a massive red flag. You need to give us a call right away. You need to speak with an employment lawyer right away. Don't let time pass in that kind of situation, because the more time passes in that new role with less pay, the harder it's going to be to undo that status quo. So give us a call right away if you're dealing with a situation like that. Next up from Funny Government. Interesting question here, a bit of a long one. I work for a non-profit. They inform me that they're going to stop including drive time as part of my wage. The rationale was that I should be taking my breaks in the car and lunch as well. I asked about the farther areas we drive to, 90 minutes each way. The response was the same, that no more driving time would be paid. I went to my other staff to tell them about the changes. We all agreed that it didn't sit right, nor that it seemed illegal, or illegal perhaps. The boss was listening around the corner and I was fired on the spot. Is this legal? Wow, Funny Government, what an interesting question and a very difficult situation. I'm sorry that you had to experience that. There are a couple of issues here, Funny Government, and I hate to sound like a broken record here, but do yourself a favor. If you haven't already, give us a call at the office. This is a situation that really requires a discussion because I've got a couple of issues with your employer here. First and foremost, if you are driving for work, and particularly if you are driving between work sites during your workday, that should absolutely be time paid, because you wouldn't have to be driving if it wasn't for your work, of course. This is not leisure time. This is not driving even to and from the office. I mean, the law is very, very clear that your commute into the work, whether that's an office or whether that's a factory or whether, it's any kind of construction site, anything really, your commute from home into the office isn't paid. Right? But during the workday, if you're having to commute for work, that time certainly should be paid. And listen, does your employer have to pay your lunch hour necessarily? No. Actually, the Employment Standards Act in Ontario allows breaks for lunch and certain amount of breaks per day that are unpaid, right? So, an 8-hour workday might really be a 7-hour a workday when your lunch is included, and so you're not necessarily paid for that time. But the drive, and maybe that's included in some of the driving, but if you're having to drive more than that, then that time should absolutely be paid, and that's issue number one. A Funny Government. So your instincts here and your employees' instincts here are correct. There is something fishy about this. Chances are a lot of that drive time should be paid. Here's issue number two. In Ontario, at least, and if you're in Ontario here, then this applies to you. And if, mind you, if you're in another province in Canada as well, the rules are probably the same. If you're in the States, if you're anywhere else in the world, I hate to say it, but this probably isn't accurate information. You need to consult local employment laws. Let's say in the US, employment laws vary state to state. So it's important to know what the rules are in your particular state or province. But if you're in Ontario, your employer, and this is a very strict rule, your employer is not allowed to terminate you. It is illegal to terminate an employee because they voiced concerns about their employment or about minimum employment protections that they have, such as wages earned. So what your employer did here by firing you on the spot, because you had concerns and were discussing concerns about paid time, paid work time, that is illegal. It's a breach of the Employment Standards Act in Ontario. That's the legislation in Ontario, by the way, that governs kind of minimum employee protections and rights. That may very well be a breach of that employment standards legislation. And again, I mean, there's no two ways about it. That is illegal. So that is massive leverage, Funny Government, that you might have over your employer now. Not only did they not pay you for proper time work, they may have violated your employment rights by terminating you for having voiced those concerns. Please reach out, give us a call. This is a very serious situation where you need the assistance of an employment lawyer. Do yourself a favor, and here's another general tip for everyone out there. When you're dealing with these kinds of employment disputes, whether it's a termination and a severance claim, or maybe you feel your employer hasn't done something properly, do not, and I don't care what province you're in Canada, do not go to the provincial Ministry of Labor or Employment Standards branch right away. The Ministry of Labor might be good for some things, like maybe vacation pay or overtime pay, more minor issues like that. But when you're dealing with a severance claim, or you're dealing with an illegal termination, or you're dealing with any changes to your work, i.e. constructive dismissals, do not go to the Ministry of Labor. They will not be able to assist you. You need to speak with an employment lawyer instead and make sure that you have an employment lawyer representing you when it comes to these issues. The Ministry of Labor can only enforce your kind of minimum entitlements, and oftentimes that's a fraction of the protections and the rights that you have as an employee in the workplace. All right, we've got about 5 minutes left, and we'll get to the last couple of questions here. Thanks so much for all of you who have already posted your questions and had them answered. Hopefully, I'm pointing you in the right direction and giving you the information that you need, at least maybe even as a starting point to get you on the road to resolving that workplace issues. Renee is up next. Renee asks, is a company allowed to terminate you after the 2 months with no severance? No employment contract was signed, or is 3-month probation automatic with or without an employment contract? Renee, another great question. We get asked about probationary periods and short-term employment all the time. If you don't have an employment contract, or I'll give you another example that's pretty common. If you have an employment contract, but there's nothing in there about probation, you can be let go after 2 months of employment. So there's nothing that's protecting your employment at all costs for that initial probationary period or the first few months of your employment, let's call them. And I will make a general point here as well, if I could take a brief step aside here. Do keep in mind, everyone, and again, when we're talking about non-unionized employees, keep in mind that nobody's job is ever guaranteed for life. An employer does always have the right. You can be the best employee in the company, you can have good performance reviews, you could be doing well. Your employer can still make the decision to let you go. Your job is not promised to you for a certain amount of time or forever, even. It's a little bit like a personal relationship. You can always break up with someone or decide to end the friendship with someone. You cannot force that other person to stay in that relationship. And so your employer doesn't have to stick with you. They can make the decision to end the relationship. But to answer your question, Renee, even as a 2-month employee or a 3-month employee, or you could be a 30-year employee, again, your employer can make that decision, but you are owed severance in that situation. And the silver lining here, it's never a good situation to be let go from one's job. That's for sure. It's always difficult. It's always extremely stressful. But the silver lining here is that even as a 2-month employee, Renee, you are still going to be owed severance. We see this every single day as employment lawyers. Even employees with very little length of employment, with very short terms of employment, will receive several months, not weeks, months of severance. Again, we deal with this all the time. You know, there are lots of decisions even out of our courts in Ontario. You know, for example, I represented once an employee with 6 months of service who received a 4-month severance package. And I say that, you know, I give that as an example, not to say that that's extraordinary. That's actually correct. That's the correct amount of severance for employees with short service. So even as a 2-month employee, Renee, your severance entitlements may even be actually more than 2 months. They may be 2, 3, 4 months, even potentially based on your age and also position with the company. So your employer can let you go, even if there's no probationary language in your employment contract, but you would be owed severance. If you've been let go from your job, do us a favor, do yourself a favor as well. Give us a call at the office. Visit pocketemploymentlawyer.ca to get a sense of what your severance entitlements are, and then let's tailor a plan to figure out how we're going to pursue your proper severance entitlements. Renee, if you were let go after 2 months, I doubt you received any kind of reasonable severance offer. Maybe the company offered you a week's pay. I wouldn't be surprised, and that's clearly not enough for somebody in those circumstances. All right, next up is In the Berg. In the Berg says, my wife received a letter that she was being let go from her position, but she is currently on sick leave, going on 2 years. What should I do? Interesting and difficult situation in the Berg. If so, the situation does very much depend on whether your wife is permanently disabled or whether she is still temporarily disabled. If there is a chance in the Berg that your wife is going to be able to return back to work in the foreseeable future, So if she is on the mend, and even, by the way, even if on the mend means a year from now, she might be able to return back to work, but there is some sort of rough timeline where she is going to be recovering from whatever illness or disability she is currently dealing with, then your employer cannot let her go in the circumstances. Her job is protected by law, and your employer effectively, her employer that is, pulled the trigger too quickly in letting her go. And that is very clear. And she would be owed severance in the situation, certainly, but also likely additional damages, human rights damages, we call them, for again making that decision too early on in the medical leave of absence. A 2-year medical leave of absence isn't overly lengthy in the grand scheme of things in the Berg. So I wouldn't be worried about that 2-year mark necessarily. Now, here's the other side of that coin. If your wife is permanently disabled, and this does happen from time to time, if she is dealing with an illness or an injury or any kind of situation where effectively the doctors have confirmed already that she is never going to be able to work again, in Ontario at least, your employer does have the right to decide to end the employment relationship. It's called, the legal term here is frustration of contract. Make a note of that term and even do your own research and look it up a little. Frustration of contract is what it's called. Frustration of contract occurs when, and basically through no fault of the employee, it's not her fault, of course, that she's on medical leave of absence, and no fault of the employer either, the employment relationship simply isn't able to continue. The contract of employment, so to speak, even if it's a verbal contract, it becomes frustrated, quote unquote. It becomes impossible to continue. And in that case, your employer, her employer, would have the right to end the relationship. In Ontario, in the Berg, employees are still owed an amount of severance in those situations. It might not be the employee's full severance entitlements, but it would be an amount. And so, again, I will reiterate the advice that I've provided throughout this segment, and we're coming up against the clock here, so we're gonna end it here, everyone. Do yourselves a favor, reach out. We have a team, by the way, as well, of disability insurance lawyers that might be able to help you on the disability insurance side as well if your wife is receiving benefits. And we have lawyers that deal with both employment law and disability insurance law, and can provide kind of wholesome, comprehensive advice when it comes to these kinds of situations. If your employer, if your wife's employer has told her that they're terminating her in this situation, please reach out right away. Let's have a chat. Happy to have a chat off air, even myself if need be, to help guide you through the situation. We will leave it here, folks. Thank you all so much for your questions. They were excellent, excellent questions today. We've got another live stream coming tomorrow, I believe. And so if we didn't get to your question today, feel free to tune in tomorrow at 1 p.m. Eastern Standard Time and go ahead and ask your question there. And I promise we'll get to it. Until then, everyone, have yourselves a great rest of the day and take care.